Welcome to PrimePay's monthly broker series webinar here in April. We are grateful that you've taken some time to sit with us here today during this webcast. My name is Steve Jackson. I'm the Senior Vice President of Strategic Development and Channel Sales, and I want to wish you the best for joining us, and I trust that you will gain a lot of good practical understanding here today on today's topic. Let me just lay down some of the logistics and ground rules, I guess, of the webcast here today. As you all have probably noticed, your phones are muted, and that's to help with a lot of the background noise that comes with these. So, but we still want to hear from you, and as we do with each of our webinars, we are recording this webinar, and so you will have a chance to go onto our Broker Concierge YouTube site, usually in a couple days here after the webinar, to view that then at your leisure, so you'll always have an opportunity. But we also want to hear from you during this webinar as well. And so if you have a question, please feel free to go ahead and go into your GoToMeeting kind of menu bar there, into the question box. Type in your question. There's sometimes I'm able to maybe answer it during the webinar, but what we like to do is create a frequently asked questions from our webinars. And for our Broker Concierge partners, we will actually accumulate all of these questions received during the webinar here today, put that together in a nice FAQ, and get that out to everyone. So we found that that's so helpful. Not everyone's thinking of the same questions, but we really would like to hear from you and be able to answer those questions that you have. So with that, we're going to go ahead and get started. As most of you know, we try to provide a lot of rich content. The Affordable Care Act over the last 5 years has given us a tremendous amount of topics to choose from, a lot of it very technical, and these webinars are really made to be able to really provide a practical understanding so that you, as a benefits consultant, you could immediately take this information and sit down with your clients, and have a real strong value-added discussion with them. Today's topic is no different. As many of you know, ERISA, that's been around since 1974, right? Been around a long, long time. But the Affordable Care Act has certainly put a target on ERISA compliance as it relates to health and welfare benefit plans. And so today, what we thought we would do is, in painting a picture about how employers should comply with ERISA, we thought, let's identify those key ERISA requirements with your clients, and let's develop an employer case study that will really help you kind of flow through how you would have a conversation with your client and addressing those ERISA requirement needs, with them. So we hope that this will be a real practical guide for you here as you begin to have these conversations with your clients. So, as we think about health and welfare benefits, ERISA, as I had mentioned earlier, established in 1974, and a lot of the Department of Labor's focus of enforcement has been around the pension benefit side of the market. And, today's webinar is really focused on ERISA and the compliance for health and welfare benefits, but I wanted to kind of paint a picture here a little bit right out of the gate. Let's get, start right from the agenda and go right into the meat of this. What we're seeing just over these last 5 years is a stronger focus to adhere to ERISA requirements for health and welfare benefit plans. And the Department of Labor, and through their department, EBSA, they usually publish statistics and fact sheets at the end, or at the end of each year. And so this was a graph that they had just come out with their recent facts and metrics based on 2014. And it states here that the number, if you can't see that very clearly, the number of criminal investigations of ERISA plans closed by EBSA is up 30% from 2010, with a total number of 365 of these investigations in 2014. And so you can just see, at least from, that graph, I mean, if we just keep extending it, is it going to continue to grow at that rate? Maybe not. But what you definitely are seeing is a trend, right? And what you're seeing, more of a trend, could be spelled out really easily in the recent headlines from, Employee Benefit Advisor, talking more about, are your clients prepared? Are they ready for a Department of Labor audit of their health plan? And what I highlighted there was, ACA, those reporting requirements, they brought increased scrutiny of employer-sponsored health care plans. Also, I found in a great summary from Lane Powell, attorneys and counselors. They provided a great synopsis of the recent fact sheet that was created from EBSA in regard to their 2014 civil and criminal enforcement activity. But just a couple key takeaways I thought that you might find interesting. And number one here, EBSA oversees about 684,000 retirement plans. And when you think about the focus and the enforcement of ERISA over these many decades, it's been honed in around the pension market, in and around, 401k retirement plans and such. But look at that next big number. 2.4 million health plans and a similar number of welfare plans. So we're talking about 4 to 5 million health and welfare benefit plans that EBCA oversees. So as you think about the potential of additional enforcement measures, it's going to be focused in this area, right? So number two says, they're just providing more criminal investigations, but there are fewer guilty pleas, so that is a good thing. There's more civil investigations, focused on protection of plan assets and participant benefits. And then here in this last one, which I found kind of interesting, and I'll dive into here a little later in our webinar, but there is a voluntary self-correction vehicle, right? So in a Form 5500, you can participate in the Delinquent Filer Voluntary Compliance Program. And there were over 1,643 applications filed last year to disclose and self-correct violations, and there were over 25,000 applications just going through the Delinquent Voluntary Compliance Program for 5500s. Just to kind of put it a little more into perspective, the criminal investigations, they're increasing, okay? So a 30% increase since 2010, but it's not only focused around kind of the investigations, it's also focused around the recovery of assets. And so I pulled just a couple tidbits from the fact sheet from EBSA here for you to look at. But if you look at this, the total plans that EBSA has kind of requirements over consist of about 141 million workers, dependents, and includes assets of over 7.6 trillion. And so through these investigations, through these inquiries of EBSA and the Department of Labor, there was a recovery of close to $600 million that was directed back to participants and beneficiaries. It's almost $600 million. That means that an inquiry, an investigation came forth, and through an appeals process, claims, judgments, that those participants received over $600 million in recoveries from where a plan sponsor or a fiduciary or a plan administrator failed in their ERISA duties. The total number of inquiries you'll see here that I highlighted as far as the number of informal complaint resolutions was over 213,000. Understand this, is that when you think about ERISA, there are specific requirements regarding documentation, right? Notices, disclosures, filing, things of that nature, right? But a lot of the enforcement comes because an employee, a participant, a beneficiary, brings it to light, right? And so you see these inquiries, over 213,000 inquiries in 2014 came through EBSA. Civil investigation statistics, they closed over 3,900 civil investigations, with over close to 65% of those closing with results, meaning filed for the plaintiff. So you start to see some of this activity, and if you go where the money goes, where there's revenue opportunities, health and welfare benefit plans are going to be looked at and scrutinized more and more. One of the things I think confusing, or at least is discussed maybe at the water cooler, is, well, you know what? Department of Labor is only going to enforce with large companies. They're going to go to the 1,000, 5,000 plus. I mean, that's where they're going to go. And through a lot of just communication with folks that have been in on the ground floor of the Department of Labor, that's really not the case. Those large companies have their own general counsel. They've got an entire HR department. In a lot of ways, yes, they do some things wrong, but in a lot of ways, they do it absolutely correct. And so where a lot of the enforcement activity is going to be is actually going to be in the smaller entities. Maybe not in the 2s and 5s and 10s, but is it in the 50s, the 100s, the 300s? Those types of groups and employer sizes do not have their own general counsel. They do not have their own HR team. And so they clearly could be working in a non-compliant fashion and could be easier targets for the Department of Labor. One other thing that I thought just might be interesting and just to kind of reflect what a Department of Labor audit, kind of the path that it follows. And this will vary a little bit, but I just wanted to give some perspective on what they would do. The Department of Labor audit doesn't come in because they just want to see if you have a plan document available. They're coming in generally because a participant, a beneficiary, an employee has made an inquiry, to the Department of Labor. And so what they're going to do is they're going to come in, they're going to do an initial document request, and then they're going to ask you for a response of all of those documentations that are needed. They are then going to have an on-site review and then interviews with the plan officials, plan administrator, fiduciary, plan sponsor, trustee, depending all the cast of members that would flow through ERISA. There would then be an identification of violations, if that is the case, that would be there. And then there would be either, voluntary compliance from that plan sponsor and how they're going to make those corrections, or there could be certainly a settlement agreement, and then a closing conference and a closing letter that would be subsequently followed. So a time frame here from a Department of Labor audit can last a few weeks to a year or more, and that's just dependent on the, what type of an audit and the breadth, of what that audit needs to cover. So I show all of this to say, to some degree to go to you. So what is your role? How do you fit into this picture? How should you as a benefit consultant be able to reach out to your clients and have this discussion? Do you want to be put into a position where maybe you're getting into advice on this? Does your E&O cover it? I'm sure that many of you wonder, how far can I take it? But I think that there are things that you can do that you can add strong value add, right, to your clients. I think for the most part, most clients, most employers want to do the right thing. I think to some degree, employers don't necessarily want to be told they've been doing the wrong thing. Just hearing that, okay, I don't really like you very much, kind of comes to mind. But once they get over that, they do actually want to do the right thing. And you sit in one of the most, I think, valued, trusted advisor positions with your clients that actually have more knowledge in this area than you might think and can actually help your clients determine exactly what due diligence they're responsible for, specifically on ERISA. The Department of Labor states that 3 out of 4 employers are out of compliance with ERISA. Whew, wow. Think about that. So you have, think about just current clients, but think about, if you're an agency, a broker that, hey, you want to attract new clients, you're out there sourcing new business. Here's an opportunity for you to differentiate out there, to really showcase kind of that compliance piece. So take some notes. Let's go ahead and dig into a kind of a case study here, an employer case study, where we'll walk you through some steps on how you can actually guide an employer through the necessary ERISA requirements. One of the first things, let's build a foundation first, and this is my only kind of ERISA 101 that I want to do here today. But many questions that we get comes down to the fact of, well, Steve, what plans are actually ERISA qualified? Which ones should I focus on? Should I literally just go through the litany of all the plans, that the benefits, the offerings that the employer is providing? I mean, how should I do that? How do I know? Okay, so this is a very simple definition, but a lot of times we'll point to whether a plan that an employer is offering, whether it would be considered an ERISA qualified plan or not. So 3 simple things, and some of these are like no duh, right? So number 1, there must be a plan, a fund, a program, okay, a long-term disability plan, a dental plan, a medical plan, a health FSA, I mean, what benefits, what offering is that employer providing? So there must be a plan. Number 2, one that is established or maintained by an employer. So we're talking about an employer-sponsored plan. Not necessarily talking about individual policies, things of that nature. It's a plan or a fund or program established or maintained by the employer. And then number 3, did they establish that by the employer for the purpose of providing one or more benefits to participants and beneficiaries? Now, those are 3 simple things, right? Kind of logical steps. I mean, it's what an employer generally automatically provides, as options for benefits for their employees. So when you look at the lion's share of benefit offerings that the employer will provide, generally speaking, if they fit these 3 steps, these 3 key elements, generally speaking, you're looking at an ERISA qualified plan. Okay? So let's get into the case study here a little bit, and I have named our case study here today Be Compliant Inc. Because, as I said earlier, most employers, I mean, clearly they might be out of compliance with one thing or another, but what Be Compliant wants is they would like to do their best at doing the right thing. They want to follow the rules. They want to match the regulations, and they want to, if it's black and white, let's do it. If it's gray, let's have an opinion on it, a gray issue. But Be Compliant Inc. wants to really, do the right thing. And so we're going to focus our case study here today on ERISA and really focus on the health and welfare benefit plans. And I hope that we can bring it to life here to you today. So when we first sat down with Be Compliant Inc., we've got to get a lay of the land, okay? So as I mentioned in the previous slide about the 3 elements, right? I need to kind of go through a litany of benefit options and offerings that Be Compliant Inc. is providing to their employees. So, I put a first checklist here of employees, okay? It is good to know the number of employees, right? As you have conversations now with employers, you probably are getting into not only full-time employees, you're probably wanting to understand their variable hour employees too, right? They're part-time. You might be doing some calculations about their full-time equivalents. Are you an applicable large employer? I mean, so this employee number now is actually becoming pretty important. Well, it's also very important to know how many W-2 employees does Be Compliant have. What are the benefit eligible? I mean, we now need to get a little more into the detail. So this is just a simple checklist. So first, we're going to need to look at the employees. What's the number of employees? How are they enrolled? We're going to need to ask about their group-sponsored coverage and benefits. We're going to look at any voluntary benefits or ancillary benefits that they offer. So dental and, critical illness and, cancer insurance policies, whatever it may be. We also need to look at how they are providing the benefit. Are they utilizing pre-tax deductions, after-tax deductions? We need to look at that for each of the benefit offerings that they are providing. We next need to look at some additional pre-tax benefit accounts such as HRAs, health reimbursement arrangements, flexible spending plans, health savings accounts. Those are going to be very key, and we're going to touch on how those kind of fit into the mix. We also need to understand their disability, long-term disability, short-term disability, group term life, AD&D. What are those other kind of supplemental types of benefits that this employer as a group, what are they offering? And then I list here PTO benefits, and you might be going, Steve, I never talk about PTO benefits. I mean, what do I need to know about PTO? Well, it's good to know. You need, from an ERISA standpoint, I would ask that you actually talk through how that employer provides their PTO benefits. And many times, PTO benefits are generally paid out of the general assets of an employer, and it's not a big deal as it relates to ERISA. But there are instances where it can, so you need to understand PTO benefits. And lastly, I put 401k, and for today's webinar, that's really, that's the full comprehensive look that I'm going to have on 401ks. I really want the focus here today to be on health and welfare benefits, but don't make that misleading. 401ks are clearly ERISA qualified. They require the same or similar plan documentation, summary plan descriptions, summaries of material modifications, Form 5500 filing, testing. I mean, all of those things are going to apply to 401k. But where there is a huge divide is this piece on health and welfare benefits and how should they also be treated. So that's where I'm going to focus kind of my energy here today. So let's dig into the details here a little bit, if we can. So I'm going to try to paint a picture here about what this company, their benefit offerings, what they look like, okay? And I'll kind of keep reiterating it here throughout. So if you want to take a couple notes, you can, but I'll probably be showing, similar slides to reflect these benefit plans here ongoing. So in digging into the details, we find that Be Compliant Inc. has 120 W-2'd employees. Okay, so 120. All right, so nice size group. And for the sake of the example here, this case study, I've basically assumed that Be Compliant Inc. has, they offer a pretty comprehensive benefit plan. Okay, I mean they're offering, it's strong, it's nice. They offer a lot of different types of offerings that can be suitable for many of their employees. Just to keep things simple, so to speak, and this may not always be the case, but let's just assume that all of their plans for all their benefits, their plan years, begin today, April 1st. Okay, so April 1st here is their plan years. Be Compliant Inc. offers one fully insured medical plan. All right, and this particular medical plan is a high deductible health plan option, and it does qualify for a health savings account. The employer pays 60% of premiums, okay, regardless of whether it's employee or single-only, employee-only coverage to family coverage, okay? So some things are already going in your mind, right? We've got 120 employees. We already think of some triggers from ACA that's going to be a part of this. We've got singularity here in plan years. That's nice. We've got an HSA plan. And now I know that employees are contributing also toward the medical premium as well. The other available options then, just giving one dental plan here for Be Compliant, we had found out. And then I decided, for the sake of this case study as well, let's go ahead and throw in an HRA. And so this is a post-deductible HRA that reimburses deductible expenses once the federal minimum deductible has been satisfied. So that's called a post-deductible HRA, perfectly legal and able. And so I wanted to get an HRA perspective in there as well. Since this is an HSA qualified plan, we also have employees that are opening and funding their HSA accounts, and that's certainly available for that option. There are those employees, though, that do not want to open up a health savings account. They like the fact that they can get their money quicker, right out of the gate in a health FSA. So we have folks on a health FSA and also dependent daycare account through that flexible spending plan. And then there's also the disability benefits, and there's short-term, there's long-term disability, some voluntary benefits, and I'll describe here on the next slide. PTO benefits, we had found out that they have kind of a simple PTO benefit of, employees accruing so many hours each pay period for their PTO. And then we found out, too, that, since employees are contributing, certainly here what I found out for the premiums, that this Be Compliant Inc. does offer a cafeteria plan. So that's good to know. Let's keep kind of moving. So let's go a little bit further here. Okay? There's a couple things that we want to look at first. So if we could divide this, as I looked at Be Compliant, if we take kind of this list, sorry, I'll go back here, we take this list, we now need to look at this, I think, in two different ways, okay? We need to look at it, one, where which of these benefit offerings flow under or fit under the cafeteria plan, right? So when I say cafeteria plan, that's a Section 125 plan, okay? So under Internal Revenue Code, Section 125. And so we also need to look at those benefit offerings outside of the cafeteria plan, okay? So I've kind of split it up under those two, so under the cafeteria and then outside the cafeteria plan. So under the cafeteria plan, if you guys remember your cafeteria plan definitions, or what a cafeteria plan allows for, but cafeteria plan is a benefit plan. And it allows an employer to put certain benefits that they are offering to their employees underneath or within that cafeteria plan so that the employee can make elections, they can choose their benefits, and then if they have any of their salary being reducted or deducted out of their pay for that benefit, they would be able to pay for that benefit with pre-tax dollars, right? Okay, so we have the major medical plan. So we know that Be Compliant Inc. pays 60% of the premium. The employee is responsible for the remaining 40%. So that means that under that 40%, that's going to be pre-tax by the employee. So just as a reference. Currently, there are 108 enrolled. So out of the 120 W-2 employees, we have 90% enrolled. So at 108 are enrolled here at the beginning of the plan year, so April 1st. They also offer dental insurance, and Be Compliant pays 25% of the premium. The employee is responsible for the remaining 75%, and there's currently 45 employees enrolled in the dental plan. The health savings account is completely voluntary or 100% employee contributory, where they, if you're going to participate, it's going to be employee dollars only. There are 55 enrolled in the health savings account. The health FSA, there are still those folks that like being able to make their election for the year and getting that election from day one. So and health FSA is specifically voluntary, 100% employee contribution, and there are 16 enrolled under that plan. The dependent care account, so DCAP account, that's the dependent care, that again is voluntary, 100% employee contribution, and 12 enrolled. And then under voluntary insurance, this employer also offers cancer, critical illness policies, and this is 100% employee paid, and we have 30 enrolled under those specific policies. So then we look outside. So let's still kind of create this list and kind of provide some additional kind of details. So outside of the cafeteria plan, you also then have your HRA, okay? If you recall, if an employee enrolled in the medical plan, they're going to receive an HRA where the HRA reimburses a portion of the deductible. So this is 100% employer paid. Actually flows under a Section 105 plan. So in this case, it's 108. There's 108 enrolled in the HRA, just the same as in the major medical plan. This employer also offers a group term life, AD&D, and LTD, right? And so in this particular example, it's 100% employer paid, group term life, AD&D, and LTD, okay? The short-term disability is paid from general assets, okay? So it's not insured, just paid from general assets. PTO. I'm seeing some questions there in regard to the PTO, paid time off. Generally speaking, I'd say most employers today, and certainly smaller employers, have simple ways of creating their PTO, right? You're given a certain number of days for the year. You can accrue based on a certain number of hours each pay period, and you accrue those over time throughout the year. But then there's other opportunities where there's actually dollars. It's not paid from general assets, but PTOs are actually put within a trust or a different environment that could create more of an ERISA type of a qualified plan. So in this case here, we're assuming that Be Compliant Inc. has just created a kind of a standard, more general paid time off policy, and it's just paid out of the general assets. And then also here you have the Educational Assistance Program or a Tuition Assistance Program. I didn't state that on the other sheet or on the other slide, but just, assume that they have even a tuition program, and that's generally just paid from general assets. So as you look at this, you might sit here and say, well, that looks about right, or wow, that's a strong benefit offering from this employer, which could be the case. But I wanted to give you a picture of a lot of the variances that an employer could truly have. Maybe their short-term disability is not paid from general assets, right? It's insured. So, in that case, we're going to treat it a little differently. So we'll touch on that here, at least on another slide. All right? All right, so we'll revisit that. So as we looked at that list, I'm sure what you're asking is, so what plans are subject to ERISA? What plans? So when I look at that whole list here, what are we talking about? All right, so as you look at this particular case study here with Be Compliant Inc., the ERISA qualified plan, so if we think about, okay, it's a fund or plan, it's offered by the employer for the benefit of the employees or beneficiaries, right? That's going to be ERISA qualified. Okay, generally speaking, yeah. So medical plans, the group dental plan, a health FSA, the HRA, group term life, AD&D, and long-term disability, and those voluntary benefits of cancer and critical illness, those items are also going to be considered ERISA qualified plans. We're going to need to ensure that these specific plans are adhering to the specific ERISA requirements. Each one of those, right? So each one of these as well might produce a plan, might produce an insurance certificate if it's a medical plan or maybe a dental plan, although we have a health FSA and HRA that will have their own documents as well, right? So we'll talk about that. So the other items here that are non-ERISA plans, I had talked about a cafeteria plan. Now, a cafeteria plan flows under Section 125 of the Internal Revenue Code, so the IRS, right? So that's not an ERISA plan in and of itself. So the cafeteria plan will sit kind of by itself here, at least in this conversation today. The dependent care account is not an ERISA plan. The health FSA account for medical expenses is, but not the dependent care account. The health savings account, the account itself, is not an ERISA qualified plan, right? But the medical plan that it qualifies for would be. The short-term disability in this example, because it's paid out of just general assets from the employer, is not considered an ERISA plan. But if it was an insured product, an STD in this case would be ERISA qualified, all right? In the example that I gave, which would be the general example that you would see for ERISA for paid time off, generally speaking, what you would see, probably 90-some% of the time, PTO will not be considered an ERISA plan, okay? But I would ask those questions of those employers to just dig a little deeper if there's some special things going on in regard to their PTO. And then lastly here, the Educational Assistance Program or the Tuition Assistance Program is also not going to be considered an ERISA plan, okay? So what you need to do as you kind of develop your checklist, right? You're looking over the entire benefit offering. That's kind of what I've done. I'm kind of leading you through that path of, okay, I've now figured out on the prior slide kind of all that they're offering. I see what the employer's funding. I see what the employee is funding. All right, so now I need to just figure out of that group, what are specific plans that I need to focus on the ERISA, side of the equation versus those that could stand alone, okay, if you will, okay? So let's look at those key ERISA requirements that they're going to need, kind of the key, I'll call it action items here a little bit, and we'll look at it here in a couple slides. So when you first think about compliance, most of the ERISA requirements that it surrounds are focused on two things. One is a plan document, kind of that official document saying you have implemented an ERISA plan for your employees or for your beneficiaries. You also need a summary plan description, clearly as well, which we'll touch on. So for both of these, I'll put both of these here up on the slide. A plan document is required for each ERISA plan, okay? When you think about other documentation, though, you should always take it a step further from an employee handbook side. I know you all as benefit consultants have talked a lot, in regard to, excuse me, talk to clients about, hey guys, you need to get an employee handbook set up. You got to get these things in writing, what you're offering, eligibility, and all of that. So it's important, as you think about the PTO, as I had mentioned before, or the tuition assistance program, that you're going to want to run that information through an employee handbook. One of the most important items that EBSA and DOL enforcement focuses on is the summary plan description, folks. If there's one thing that I could focus on more than, it almost seems like anything under ERISA, this summary plan description, this piece that would be provided to the employees is really one of the most important pieces of ERISA. And you need one, technically then, for each plan. So as I listed those ERISA, the list of ERISA qualified plans, you would need one for each plan. Now, we'd also, though, reference the, Section 125 and 105 plans. So there's still a requirement for a flexible spending plan, and for an HRA, you're still required to have a plan document and a summary plan description under a Section 125 plan and a Section 105 plan. So just by adding the additional ERISA compliance document piece does not remove the requirement under Section 125 and 105. This is in addition to. You also want to think of summary of benefit coverages, right? So with Be Compliant Inc., they have a fully insured medical plan. They're probably receiving that summary of benefit coverage through that carrier. And then for the HRA, depending on who is providing that, there's also a summary of benefit coverage requirement there as well. These are good questions to ask, right? I needed to ask Be Compliant Inc., okay, hey, I see you have an HRA. Do you have your plan document, an SPD for the HRA? Yes or no? Have you provided that SPD to your employees? Do you have your summary of benefit coverage produced for you for that HRA, for that group health plan? So again, these are good due diligence questions. Employers will often make changes from year to year or mid-year changes that do need to occur in the middle of a plan year. And so under ERISA, there is a specific notice requirement called the Summary of Material Modification. This is going to be a key action item for Be Compliant Inc. When they adopt the ERISA documentations. And then here as well, Form 5500. Now, I want you to think, and I'll go here on the next slide. We'll kind of show it better here on a page for you. But how many employees did they have actually overall in their company? Be Compliant Inc. had 120 employees, right? If you recall. That number is okay to have, and we're going to need that number probably for some other things. but they only had 108 on their medical plan. They had 108 on their HRA. Well, Form 5500 is going to be required here for Be Compliant. So it was important for me, and I'll dig into that here in just a second about that filing, but it was important for me to know, based on each plan offering, what is the number of participants, okay, that were in that plan, enrolled in that plan at the start of the plan year. Okay, and then if I file a Form 5500, then a summary annual report will also be required as well. Some additional duties under ERISA will also flow under fiduciary responsibilities, depending, and even fidelity bond or even trust accounts. And I just kind of put those three together to the right because, fiduciary responsibilities is always going to be a responsibility of that plan sponsor and that employer. But a fidelity bond, a trust account may not be, just based on how they need to establish their health and welfare benefit plan. So in some cases that may be needed, in many other cases not, okay? And you see fidelity bonds a lot on the pension side, on the 401k side of the aisle. But don't forget other key requirements that tie into and through this whole ERISA and ACA component as well. You know, many of these documents cover established claim procedures and appeals language, claims appeals language. It's also going to dig deeper into COBRA and HIPAA compliance. Also, W-2 reporting. What this tells you, as I went through the example of Be Compliant and what they have to offer, for my W-2, let's see here, they're not an employer that's over 250 W-2s in a year, so they won't have to report their premium in this case, but they offer HSAs. They offer a dependent care account, and that means they're going to have to put that information on the W-2. Again, just good due diligence questions to ask, because that employer is going to want to make sure that they're complying with those W-2 reporting rules as well. So let's kind of show you here now what does this ERISA thing look like. We dove down deep into Be Compliant Inc. We've kind of determined which plans are ERISA qualified. So what now? What do we do? Okay. So what plans would need to flow under this ERISA document? So what I've done here is I've shown here a few different items. Under ERISA, you can establish a plan document for each plan. So as I showed you these, 4 or so, as you see these 4, at least bullets here, you could indeed have a plan document specifically for the fully insured medical plan, one for the dental plan, one for the group term life, one for AD&D, one for LTD, one for health, so you can have one for each. But what might be more beneficial for Be Compliant is to actually create a wrap document or an umbrella plan document that would wrap, right, all of these plans under one plan document, under one plan number, so 501 or 502, whatever it may be. So these plans, what might be, because we also know that I had asked Be Compliant Inc. how many people were enrolled in the medical plan in the HRA at the start of the year, and we found that they had 108 employees. That tells me that we now need to file a Form 5500, because if you have 100 or more participants at the start of the plan year in a health and welfare benefit plan, ERISA qualified plan, you're going to need to file. Okay, and so we know already that they're going to need to file a 5500. So we've created, in this example, an ERISA wrap document that takes all of those plans and puts it into one singular ERISA plan. Okay. What I also want to reference is that these plan documents will also cover many of these items that I show you here. There are many annual notices and disclosures that need to be met as part of its compliance, ERISA's compliance. So you have the Women's Health Care Act, you have, you've got COBRA and HIPAA, you've got the Mental Health Parity, you've got the Newborns and Mothers Health Protection Act, you've got the Women's Health and Cancer Rights Act, the Qualified Medical Child Support Orders, right? There's a lot of different notices and disclosures that are in there, and they are contained, many of these, directly as disclosures directly into the wrap document and the summary plan descriptions. You also have a thing called the exchange notice, which is also part of ERISA and ACA. That is also a requirement for employers to send out. Now that's kind of separate outside of ERISA. Okay, or outside of the documents, I should say. But the exchange notice is kind of part of that. And then I added the two things here, just what Be Compliant Inc. will probably also need to provide is a summary of material modification when they make changes yearly or during the year. And then because they will be filing a 5500, they will need to also create a summary annual report and provide that to their employees. So as you think about some other key key requirements, you also, what I don't want you to forget about is kind of the Section 125. We had talked about Be Compliant Inc. having a cafeteria plan, okay? The requirements for the plan documents is still intact for the cafeteria plan, and that's going to cover the premium-only plan piece. So that piece where the employees are making pre-tax deductions for their group term life, well, actually that was 100% paid, their health FSA, their premiums for medical, their premiums for dental, so on and so forth. The health FSA, the dependent care account, and certainly contributions made for the HSA. One of the things that I want to mention, and I think I've mentioned before, but just to reiterate, under what many employers are offering health savings accounts today, and many employers are not amending their cafeteria plan documents to reflect that they actually have added that to their plan. When you see that an employer is offering an HSA and allowing their employees to make pre-tax contributions through their payroll, they're required to amend their Section 125 plan document. So a great question to ask is, hey, I see you're offering an HSA, fantastic, employees are contributing, yep, pre-tax, yep, great. Did you amend your cafeteria plan so you can add that? Ask that question. It is required. This also does not remove the ERISA wrap document, does not also remove the Section 105 plan document component, so the plan doc, the SPDs for a health reimbursement arrangement. So you notice that the health FSA, that the health reimbursement arrangement is actually on the left-hand side, right? It's included as part of the ERISA wrap document. Those are ERISA qualified plans and can be wrapped into that plan, okay? But you still need those separate 125 and Section 105 documents as well. I talked about the summary of benefit coverage notice. That's either going to be delivered by the medical plan, the carrier for the medical plan, or maybe the TPA if it's self-funded. And then on the health reimbursement arrangement, the SBC notice is required, and that's going to be provided by the plan administrator or TPA, okay, in that case. So 5500, okay, so we've created a wrap document that has incorporated all of those first four bullets on the left, that column. We have included all of those plans because they're ERISA qualified into one wrap document. We've also noted that the HRA and the medical plan had more than 100 participants in the plan at the start of the year. That means I'm going to have to file. Now, instead of, if I didn't set up a wrap document or an umbrella document, if I had done kind of what I had said in the very beginning, like, if I set up separate documents or plans for each, which I could do, what that would mean is that I would have to file a 5500 then for the medical plan, then I'd have to file another 5500 for the HRA. So I'd actually have to do two filings. But by combining these plans, these ERISA qualified plans, into one wrap document, now Be Compliant Inc. only has to file one Form 5500 filing. But when they do that Form 5500 filing, they're now going to include those ERISA qualified plans, and they're going to apply that data to the specific schedules within that 5500 filing plan requirement. So that's why I've listed those plans there as I did. Additional items for consideration, and at this point, if you've gone through this meeting with Be Compliant Inc., maybe their eyes are rolling in the back of their head. I don't know if you feel like time is, you're juggling time, right? Because you're going, well, wait, I don't even know if I have enough time to get through this rest of considerations here, Steve. But I tell you what, there's more. Because we found out some key facts about Be Compliant Inc. We found out that they have an HRA. So you better talk about the PCORI fees, the Patient-Centered Outcome Research Institute fees that this employer is going to have to pay by the end of July of this year. Talk to them about it. What are they doing to make sure that they comply with that requirement? The HRA still has the compliance for the non-discrimination testing. You're required to do a non-discrimination test under Section 105H. Employer, be compliant. Have you done your test for your HRA. The same applies for the FSA. You know that they have a premium-only plan and a health FSA and a dependent care account, where there are 3 separate non-discrimination tests for just that FSA alone. Be Compliant Inc. Are you performing that non-discrimination test? Premium-only plans. This is a key, awesome discussion right now because it's really forefront in the minds of a lot of the requirements. For a premium-only plan, we know that Be Compliant allows their employees to pay with pre-tax money. Well, Be Compliant, have you actually amended your plan to allow for mid-year permitted election changes and for marketplace status changes or stability period qualifying events? Your plan needs to be amended to include those new permitted election changes. Maybe, possibly, the medical loss ratio rebates, those could be out there, so that could be something that you could discuss with your employer. And then what we also realized is that this employer had 120 full-time, or actually W-2'd employees. Now, I may not know, probably most of them are full-time because we noticed that 90% of them are enrolled. But what about that remaining group, 12 employees or so that are outstanding? Are they variable hour employees? Well, Be Compliant, you're an applicable large employer, and you're actually over 100 employees, so that means you flow under the employer mandate here in 2015. So you better begin measuring your variable hour employee base. So another great discussion there. And then lastly, and very importantly, under 1094 and 1095, Be Compliant. What are you doing to prepare yourself for the new information reporting requirements that you're going to need to file and provide and furnish to your employees beginning in the first quarter of next year? Some really key things there, and to some degree, there's a lot just on the ERISA side, but also too on just some of these other supplemental compliance items that you're going to need to address, with your employers. So failure of non-compliance, I tried to just wrap up at least a little bit on compliance because I think a lot of employers might come back to you and say, Steve, come on, I'm not going to get audited. I'm a group of 45, I'm a group of 22, really, I'm going to get audited, really, and I'm going to get hit with these fines. I would ask this question. Have you offered at all in any open enrollment period or otherwise, even to a new hire, have you offered your employees a summary plan description for ERISA? Have you done that? Because a lot of the enforcement and a lot of examples that I'll show here are centered around just simply furnishing a summary plan description to the employees. And as you see some of these numbers here, some of the numbers can be pretty big. I won't cover, this is kind of a busy slide, but you look at willful failure there in that second bullet point. If an employer just willfully does not provide these documents, these summary plan descriptions, the maximum could be up to $500,000 or even up to a 10-year prison sentence. Okay, so it could be pretty dramatic. But look at that second bullet point here a second. If an employer fails to provide a copy of the SPD within 30 days of the request, it can result in up to $110 per day per employee. And so I just gave you an example here. Be Compliant says, ooh, you know what, I had 5 employees ask for a document, but I didn't provide it. I didn't do it. It's been a year since I've last provided that. Let's quickly do the math on these 5 employees. So if enforcement actually were to be done and done to the $110 per day, 110 times 5 employees times 365 days equals a penalty of over $200,000 for Be Compliant. And when you just start putting it in simple terms of 1 employee or 2 employees that would come, right? I showed you that metric in the Department of Labor, the EBSA fact sheet, where it said there were over 200,000 inquiries. that's from employees. That's from those beneficiaries appealing the information here in regard to what employers or carriers or plan sponsors failed to do or may not have failed to do. So one thing that I want to mention below is the Form 5500 penalties. We are finding, you saw a large number of employers on that fact sheet, over 25,000 applications of employers saying, you know what, I have not been filing Form 5500 and I better get my act in gear. And what the Department of Labor has provided is a delinquent filer voluntary compliance program. And it basically allows an employer to say, I've messed up. I have not filed my forms like I should over these last however many years, so I am going to pay a penalty, but they pay a max penalty. And so it would be better for an employer to go through the delinquent filer program, because if the Department of Labor then or EBSA goes through a regular investigation and enforcement, you're going to see fines that are going to be much greater than these numbers here. And one thing to note, the last 4 words of this slide, it says no statute of limitations. That's tremendous. So Form 5500 is extremely important. And that's why you need to begin asking those questions in regard to ERISA. How many participants did you have? Not belly buttons. How many participants, employees, did you have on the first day of your plan year? And then that Form 5500 is to be provided or filed within 7 months after the end of that plan year. Okay? So let me just touch on, I wanted to just give a couple examples here of employers failing in some form or capacity to produce an SPD, and where there was a lot of thought that a certificate of insurance was enough, and it's not. A certificate of insurance is not a way to provide an ERISA compliant document to the employee. So as you see here, the penalties can be pretty severe. I mean, just for not providing a participant in a timely manner, that SPD. And as you go into the statute, I just kind of highlighted here, you know, any administrator who fails or refuses to comply with the request for any information which such administrators required, you know, by the subchapter to furnish to a participant or beneficiary. And they talk about 30 days. I mean, so it's that failure. So one of the things that I wanted to show, this was just a kind of a brand new case that actually had come to a kind of a settlement, a judgment, and I thought it would be important to kind of show. And this is a case, it just, as you see there, March 2nd, 2015, it was Thomas versus Cigna. And it had to do, the case summary was that the employer would tell a new hire that they have the SPD and it's available to them on the company's intranet site. And so the employer had posted the SPDs onto the company's intranet site. And they would only really state it to the new hires that it was available there, although it was always available on the intranet site. And so I think for most of us here, we'd go, that's pretty sweet, right? I mean, sure, hey, make it available, no problem. Well, get this. Once, in this particular case, this was a life insurance, so the plaintiff was seeking to recover life insurance benefits, you know, owed to him. And beneficiaries, basically as the case came through, the judgment stated that the SPD distribution at the time of hire is inadequate. Just simply making it available to them at that time is completely inadequate, and the verdict went to the plaintiff. So here the employer had an SPD, had actually a, you know, a schedule of benefits, and yet here the employer didn't do enough to inform the employee, you know, actually in this case, the beneficiary, the opportunity to review that schedule of benefits in an easy to read manner. So very interesting, right? To some degree you go, oh my word, you know, there's just so much kind of to this, but it's making it available. So we recommend, listen, you not only want to recommend making this available to them in a paper form to your employees at a new hire, but you should probably look at doing it on an open enrollment type of a basis and provide it not only in an intranet, which is good to have, but also provide that in a paper form there as well. So some might ask, so what's the detail here? I mean, what do you guys really ultimately provide here in regard to, ERISA, and how can we be ensured that, our clients' ERISA compliance needs are actually going to be properly met? So PrimePay provides the full plan document personalization and preparation. So we're going to ensure that for any health and welfare benefit plan, that every ERISA compliance documentation and requirement is going to be met. And that's going to include not only the plan document, and it's heavily customized, but it's also going to be the summary plan description, the SMM, the summary of annual report. If, in this case, with Be Compliant Inc., we were going to need to create an SR report, but if they didn't file a 5500, we would not, but it is included. We would include the annual notices and disclosures, and also provide Form 5500 filing if that is needed for that particular employer. So why PrimePay? The main thing here is that you need to ensure that all of the ERISA requirements are satisfied. Employers are also going to want a way to be able to simplify the amendment process, and you can do that through umbrella or wrap documents by combining, many ERISA plans, putting them together into one plan document, and you eliminate a lot of the documentation risks of, well, I forgot to change, I changed the eligibility on this plan, but I forgot to change the eligibility on this other plan. All right, well, you eliminate that risk when you kind of bring all of those by simplifying everything into one specific umbrella document. PrimePay has put together an administrative and technical administrative support team that is bar none, one of the tops in the industry. We have ERISA experts, we have an ERISA attorney, ERISA experts with over 15 years of experience, folks that have experience directly with the Department of Labor, and we are independent of carrier selection, so we're carrier agnostic. As your employers change their benefit offerings, we can make and move with those changes as well. And we've also tried to remain very competitive by including all-inclusive fees. We've tried to create an ERISA solution that offers ERISA attorney firm expertise and documentation and customization and personalization, but be able to offer it at a price that is very competitive in the market, so which we're really excited about. So our PrimePay guarantee states that your benefit documents, that Be Compliant Inc.'s documents, will be compliant with ERISA. It's going to include all mandatory ERISA plan provisions, all mandatory disclosures that would flow under COBRA, USERRA, HIPAA, and certainly many other applicable federal mandates, and also address recent changes under healthcare reform. One of the ways that we want to help you and assist you through the process with your clients, because many of you might sit here and go, Steve, I don't, I mean, that's awesome. You've provided some great information and kind of leading my client through the process, but is there a way for me to maybe more simply do this, and then I can turn this over to you or something like that? So we created an ERISA compliance checklist that's a pretty simple checklist, very simple. But what it could do is actually help you start a conversation, about their benefit offerings and about where they are doing great with ERISA compliance or where they're falling short. And this is a great way to perform due diligence either with your clients, but also, think about it, also in your prospecting efforts. It's a great way to sit down and just say, hey, my agency, we do things a little different. We differentiate here and really provide strong value-added solutions, and one of these is through our ERISA compliance. I can't, since it's April 1st, I would be remiss if I failed to mention to you our special April promotion. And although it doesn't specifically result around ERISA, because we have extremely competitive pricing there, we actually have a special offer, though, on our payroll services for the month of April, and it's specific to only health brokers, benefit consultants, and their clients. So for the month of April, if you start, or your clients that you refer start payroll services between now and April 30th, your agency or your clients will receive 60 days free of payroll services with PrimePay. And like I said, this is a specific promotion going on right now in April that's available only to your agency or those clients that are referred by you, okay? So with that, there's a ton of information there. As I'm looking at a lot of the questions that are coming through, they are great questions. And what we will do is this: we're going to put together an FAQ that will help kind of walk through a lot of those questions. Our BC partners, you're going to receive a list of those questions and be able to view that then at your leisure. We're going to make sure you get your hands on an ERISA compliance checklist. We will be providing the presentation slides for you to review. And for all of you, we will be posting this webcast on our Broker Concierge YouTube channel, and just look for that here in a couple days once that gets posted. If you're unsure whether you are a Broker Concierge partner or would like to learn more about how our Broker Concierge Partner Program is helping assist, drive solutions, provide compliance strategies, to our broker partners. If you would like to learn more just about how we're doing that, please feel free to connect directly with our Broker Concierge team at the number or email listed there, and we can point you to the right sales professional to get you to learn more about that program, because we think that we can put a lot of tools and resources and content and solutions directly in your hands to really drive more and greater value to your clients. So with that, that's going to conclude our webinar here today. I can't thank you enough for joining. Our next webinar will be here at the beginning of May, and we look forward to you joining us then. So with that, have a great day, and we'll see you real soon.